Nuisance. Introduction. Nuisance is an important tort dealing with unlawful interference with the enjoyment of land or rights of the public. It protects a person's right to peaceful enjoyment of property and public rights. Nuisance may affect an individual or the community at large. The law of nuisance balances individual freedom of use of property with the rights of others. It is frequently tested in LLB examinations. Meaning of nuisance. Nuisance means an act which unlawfully interferes with the use or enjoyment of land or with public rights. The interference must be unreasonable and cause inconvenience, discomfort, or damage. Mere annoyance is not enough. The act must materially affect ordinary comfort. Nuisance can be continuing or recurring in nature. Types of nuisance. Nuisance is mainly of two types. Public nuisance. Private nuisance. Each type differs in nature, scope, and remedy. Public nuisance. Meaning. Public nuisance is an act which interferes with the rights of the public at large. It affects society as a whole or a considerable number of people. It is both a tort and a crime. Generally, an individual cannot sue unless he proves special damage. Case law. Attorney General vs. PYA Quarries Limited, 1957. Facts. The defendant carried on quarry operations causing vibrations, noise, and stones flying onto nearby public roads and houses. The activities affected a large number of people living in the area and using public roads. Held. The court held that the activity amounted to public nuisance as it materially affected the reasonable comfort of a class of people. An act affecting a section of the public constitutes public nuisance. Private nuisance. Meaning. Private nuisance is unlawful interference with a person's use or enjoyment of land. It affects specific individuals rather than the public at large. The interference must be substantial and unreasonable. Temporary inconvenience is not enough. The right protected is a private property right. Essential elements of private nuisance. For private nuisance, the following elements must be proved. Unreasonable interference. Interference with use or enjoyment of land. Damage or inconvenience. Unreasonable interference. Interference is unreasonable when it exceeds ordinary tolerance. Courts consider locality, duration, intensity, and nature of activity. What is reasonable in an industrial area may be unreasonable in a residential area. Motive of the defendant is usually irrelevant. Balance of convenience is examined. Case law. Sturges vs. Bridgman, 1879. Facts. The defendant ran a confectionery business using noisy machinery for many years. Later, the plaintiff built a consulting room nearby, and the noise disturbed his medical practice. Held. The court held that the noise amounted to nuisance. What is reasonable depends on the locality, and prior use is no defense. Damage or inconvenience. The interference must cause actual harm or substantial discomfort. Trivial or imaginary discomfort is not actionable. Damage may be physical, mental, or material. Sensitivity of the plaintiff alone is not considered. The test is of an ordinary reasonable person. Case law. Robinson vs. Kilvert, 1889. Facts. Heat from the defendant's business damaged the plaintiff's sensitive paper stored in a nearby room. The heat did not affect ordinary use of property. Held. The court held that there was no nuisance because the interference affected only abnormally sensitive property. Defenses to nuisance. Common defenses include prescription, statutory authority, act of God, consent, reasonable use. Remedies for nuisance. Remedies available in nuisance are damages, injunction, abatement. Conclusion. Nuisance plays a vital role in protecting property rights and public convenience. It ensures that one person's use of land does not unreasonably interfere with others. By distinguishing between public and private nuisance and applying the test of reasonableness, courts maintain social harmony. Nuisance is an essential topic for LLB examinations and practical understanding of tort law.